Welcome back. Thank you for being here. Thanks for coming back. Thanks for sticking with us. That was a great discussion on CISO liability. We've never had that before. And as I was taking a lot of notes during it because there's so much to write in this subject. And these CISOs are the unsung heroes in companies. And now they're getting crucified. It's crazy. So let's turn to our next. We're taking a complete turn here to data privacy, which, as opposed to being narrow like CISO, this is a much, much broader topic. So hopefully you'll ask some questions. You get to talking about things in the chat, but it covers so much ground. So let's get to it. I'll give you the introductions, and then we'll get right into it. Our first speaker is Demian, one of the IR all-stars at Wilson Sonsini's privacy and cybersecurity practice. What you'll immediately notice from Demian's bio is that, like so many speakers today, he has some serious creds, including a stint with the Washington, D.C. U.S. Attorney's Office, where he served as national security cyber specialist and computer hacking and intellectual property prosecutor. So he was the CSIPs, also doing national security in Washington, D.C. But what you might miss in his bio, and you definitely miss this, is that what the credential that Demian has means. Because in the DC U.S. Attorney's Office, where I also once worked, it serves as a traditional DA's office. So most prosecutors there start out doing cases from guns, drugs, and domestic violence to homicide, murder, and other intense felonies. So Demian has handled cases ranging from prosecuting global hacking syndicates to the famous Pizzagate case, where Demian got caught up in the so-called Pizzagate conspiracy theory. You may recall this is where a Washington, D.C. pizzeria was somehow the hub of a child sex trafficking ring, and a man entered the pizzeria under the auspices of investigating, carrying a sidearm and an assault rifle and terrorized the patrons in the stair there, and then the staff, and eventually fired his AR-15 into the lock of a door because he believed the trafficked children were being held there. It was a storage closet. No one was physically harmed in the incident. The man was arrested, and guess who was the prosecutor, the lead prosecutor, Demian, which resulted in the shooter being sentenced to 4 years in prison. So what would Demian's theme song be? It has to be Pompeii by Bastille, because when the walls come tumbling down in the city that we love, be it because of cyber attack or an AR attack, Demian is there to protect us. So welcome, Demian, to your first IR Masterclass.
Thank you.
Next up is Dan Greene. Dan, great to see you. What the bio of our next speaker will tell you is that he is a multifaceted IR and litigation partner at the law firm known as Octillo, one of 3 law firms today whose sole mission statement revolves around cyber. What you may miss from Dan's bio is that before joining Octillo, Dan helped lead a public sector venture capital investment portfolio, creating hundreds of jobs for high growth startups. And then he joined one of the startups. He has spent his career on the front lines defending hundreds of companies who find themselves first under attack by cyber threat actors, and second under attack by the US government, who can sometimes, unfortunately, victimize the victim twice. Meanwhile, Dan has built up a terrific reputation for advising healthcare, retail, financial companies, even cannabis companies, where the regulatory landscape is constantly changing and, like privacy laws, can vary considerably depending on jurisdiction. That makes Dan a mix of Perry Mason and Snoop Dogg, a very powerful combo. And his theme song, It's Gotta Be Cool by Dua Lipa, because that's what Dan is. He's cool. Welcome, Dan.
Thanks, John. Good to be here.
And next up is Amelia Gerlicher of Perkins Coie. She's our moderator today. Her bio will tell you that she focuses her practice in the areas of privacy and data security, counseling clients on preparing for and reacting to cyber attacks, as well as helping clients assess and address the privacy and data security risks that arise from a wide range of commercial activities. But what you may miss from her bio is that her experience is extraordinarily broad, from advising companies on how to protect sensitive healthcare information and avoid becoming potential targets of data losses, to helping clients defending against illegal spamming, pretexting, harassment, and other forms of malicious behavior that interfere with clients' websites. So that's really a great specialty, helping clients when they are under siege, not necessarily from only cyber attackers, but also from old-fashioned bad actors who use technology to hurt companies and hurt people. So Amelia's a real IR crackerjack and a client sentinel, and a rare combination of what I would see as Natasha Romanoff from the Avengers and Nancy Drew from those books that everyone read when they were little. And her theme song, you guessed it, Fearless by Taylor Swift. Welcome, Amelia.
Thank you, John.
And then finally, Adam Solander from King and Spalding. As a data privacy and security healthcare and employee benefits partner at King and Spalding, Adam provides counsel on data breach and cybersecurity issues across various industries, particularly healthcare, where privacy is a huge deal. In fact, Adam is probably one of the most qualified IR lawyers in the area of healthcare companies. Healthcare companies face some of the toughest, most confusing, and most confounding privacy rules today, both across the USA and, of course, globally. And Adam may be the only lawyer you hear from today who is a certified CSF practitioner, a designation given by the Health Information Trust Alliance, certified in an array of regulations and standards, including, you ready for it? High-tech, HIPAA, PCI, JCAO, HO, CMS, ISO, NIST. The list goes on. It's an alphabet soup of regulations and standards. Even the most minor screw-ups can crush a healthcare company. Adams loves to talk about the so-called unarticulated standard of HIPAA compliance. I'm sure you'll hear about it today. The safe harbor of HIPAA compliance and the legal impossibility of HIPAA compliance. Adam is the Dr. Watson of Sherlock Holmes fame of IR, and we are thrilled to have him speak at his first IR Masterclass. As for a theme song, I have to tell you, Adam, I listened to an hour-long podcast of yours on healthcare and cyber, and I still came up with nothing. Zip. I could not figure out a theme song for you. So I'm going to leave that to the audience to suggest at the end of this, if anybody has a good theme song for Adam, for if we're lucky enough to get him next year, I can bring it up. So thank you all. And Amelia, I will welcome Adam.
Thank you.
Absolutely. And Amelia, I'll turn it over to you and look forward to hearing this panel. And then after that will be the insurance panel, and then we'll be done. Stick around for the insurance panel. That's the panel I'm doing. I hope to see you there. Thanks.
Thank you, John. As always, slew of colorful introductions. So we're dealing with data privacy, both pre-attack and post-attack, and kind of how it all comes down in the middle. We're going to start with one of the most impactful changes that's happened over the last year for public companies and those that aspire to be. As I know has come up a lot today, the requirement that material incidents be disclosed within 4 business days and to provide detailed information about risk management and governance. And there's been a lot of commentary about what constitutes a material incident and how you figure that out. So I want to take us in a slightly different direction and start with preparation. Dan, I wonder if you could talk about what changes regulated companies should be making to be in position to comply with this requirement.
Yeah, it's obviously been a popular topic today, so I hope no one has created a drinking game around how many references there were to it. But when we think of it through the lens of preparation, I think it dovetails really easily into incident response planning and training around incident response plans, because I think for everybody listening, incident response plan is where you are using a framework to think through what personnel are involved at what points of the stages of an incident response, from detection and eradication through remediation and recovery. And part of that process includes looking at the matrix of the impact and the scope generally of an event to determine what kind of response we're going to have. And that can serve as a natural way to also look at materiality. We're no longer looking at materiality as a 5% of annual revenue sort of threshold. So you want to look at something you want to look at an event through that highly contextual manner. And I think there's an opportunity to add to every incident response plan and add to every training or tabletop exercise the same assessments. And whether it's a playbook or an appendices, additional guidance added to the incident response plan, therein lies that opportunity to assess what's happened, not just from what it means to our incident response plan, but also what it means to that reporting and that reporting threshold. And at the same time, be aware of how to avoid boxing ourselves in. Because we've seen that now the SEC may be looking to mine some of these materials for statements to make claims of material misrepresentations. Whether they can be successful or not with that, we'll see. But also to be aware of, all right, we're talking about different factors, but we're not necessarily identifying exact scenarios as material or not, because they're so highly contextual. And when you're in a vacuum talking about it, you might say, well, scenario F, like that must be material. But then in reality, once you've collected the details and you're trying to understand what's happening in that short 4-day window, then we're really thinking about, well, this is more scenario F-ish. It doesn't quite match what we thought before. So there's the ability, again, to think of it more as a matrix and add it into our incident response planning than to necessarily lose ourselves with very strict, and restrictive ideas of what materiality may be. And at the same time, studying what's going on in our environment, right? Look at what the other filings look like so we understand sort of what the ecosystem around us is considering material, and remaining aware of that, so that between the time we may draft an appendices or even be reviewing it, we're also monitoring for what's happening amongst other entities that are reporting and disclosing an incident. And then, of course, looking at it through every incident through the lens of, what are we going to have to report in our annual disclosures? And how are we going to show that we've learned from some of these things if we've reported anything, or otherwise that we're not just growing increasingly vulnerable, but we're actually demonstrating some resilience in the way that we are managing risk and assessing risk throughout. So I think really it's, unfortunately, because we seem to have less and less bandwidth to study all of these regulations, it's more forethought and it's more planning around that incident response plan and how we're considering disclosures in a light that is not just favorable or most favorable, but also gives us room to build.
Okay. I think one thing that was kind of implicit in your comments that I just wanted to call out was the degree to which that is going to have to involve not just the kind of the cyber lawyers that have been working on the plan, but also your securities counsel and the people who otherwise are thinking about those public disclosures on a regular basis and making sure you're harmonizing both the understanding of your systems and how you're going to do those disclosures.
Yeah, in a time-sensitive space, that compression of availability and time makes the chance of a misstep higher, right? So let's walk through it together, get everyone in the room well ahead of time in order to be familiar with the different voices and the different considerations to get it right and be prepared. Absolutely.
Yeah, and that's actually a point I wanted to pivot on and talk about that immediate kind of post-incident issue where you've got those 4 days. Demian, can you talk about the practical considerations that you keep in mind as you're going to make a decision and how to go public and how to manage that decision?
Thank you. Yeah, it's a great pivot because really we're talking about an event that is potentially or likely or going to be disclosed. I think that the entire team has to take an interdisciplinary approach. It needs to incorporate people who understand the different aspects of the business, different aspects of the legal requirement. Thematically, it's just a very different way to approach incidents when you have the SEC disclosure obligations coming on to you. So I'm not talking about the decision whether to disclose, but when you know a disclosure is going to happen, how does that change your response to the incident? And I think it actually does have to change it pretty dramatically for a lot of reasons. First of all, obviously, you've got the time sensitivity of the 4-day disclosure if you know that it's a material incident. But even if you don't, there is a time pressure to the way that there's a time pressure based on other deadlines. So, for example, let's say it's not a material disclosure, but your 10Q is about to be filed or your 10K is about to be filed. Let's say that there is an incident, and when you're investigating that incident, maybe you haven't even crossed the materiality threshold. You realize that there are problems within the security program of the company that make past disclosures look misleading. And so you have to think about an incident in a very interdisciplinary, well-rounded way that can't be cabined to data breach notification obligations, can't be limited to people who understand information security, but it has to be people who understand the business and the SEC disclosure context. And, I think it presents real challenges for, how you structure your investigation. For example, under a lot of data breach response aspects, and when you're trying to figure out what are the notification obligations, you may be able to sort of say, okay, here is the set that needs to be reviewed. We're going to have it reviewed, and then at the end of that, we're going to look at it and we'll figure out what our disclosure obligations are. Under the SEC framework, not only do you have this sort of time sensitivity of a potential 4-day disclosure requirement, but there's the possibility when you do make a disclosure, whether it's your 10Q, your 10K, or an 8K, you have to account for the knowledge that the company or its agents have at the time you're making the disclosure. So you can't wait till the end of a review process and sort of set aside all that knowledge that you or maybe your agents are acquiring during that period. Your disclosures have to account for what's going on, what's known by somebody working on behalf of the company at that time. And that makes it very challenging in figuring out not only whether we have to make a disclosure, but how the disclosure has to be shaped, and how do you structure your investigation knowing that these disclosures are coming up, even if it's not just the 8K. So I think that this really is going to be a game-changing role for public companies for incidents that are either maybe material or definitely material, or there's going to be some other disclosure forcing function out there.
Yeah, I think those are a lot of very interesting points. I wonder, how do we think about privilege when we're going to have to go out that fast? Does it change the way that we've traditionally thought about protecting incidents and keeping everything under wraps until we're ready to go public?
I don't think that it changes the analysis, but the context is now different in a couple of different ways. I mean, first of all, the speed that you have to act. I don't know how much that changes it, but second, it's the type of scrutiny that you're going to get. The SEC is now conducting proactive outreach after incidents that become public and asking in questions, even in an informal way. You have to be prepared for that. Independent auditors, when you're coming up to your 10K, for example, independent auditors are asking questions, and the answers may only exist in a privileged space under the traditional, response plan. Now, your auditors are asking for information that makes it very difficult to keep everything under privilege. So I think there does have to be a rethink, even though overall the considerations are the same. It's just now you're dealing with different facts, different people who are getting more aggressive about asking questions.
Yep. I thought that might be the theme of kind of all of the evolving regulatory space in this this year and as it moves on. So once the initial evaluation of the incident has passed, and it's determined, maybe this particular incident is not material, what best practices should companies keep in mind with regard to their SEC obligations? Adam, why don't you take this one?
Yeah, absolutely. And, this is one of the nice parts. Everybody's talking about change here, but I think your question falls really into best practices. Anytime you're doing any kind of breach analysis, anytime you're doing a materiality impact or risk of harm analysis, depending on what data privacy and security law is implicated, that's generally going to be a close call. It's something that you can't just say, hey, this isn't material. This is the loss of an encrypted cell phone. Those types of things that obviously aren't going to be material. This is something that requires some sort of iterative process where you're looking into it. So that by definition is going to be a risk. So ultimately, in information security best practices, these types of risks need to be incorporated into any kind of risk assessment mitigation plan. They need to be on risk registers. They need to be tracked over time. One of the issues that we're seeing, especially with the SEC rules, is there's a lot of risks that could potentially be material, but just haven't necessarily matured yet. APTs are a great example of this. A ton of our clients, they're aware of APTs at pretty much all times, especially if they're somewhat, larger company or, in any kind of space where they may be a threat for those types of activities. That's obviously is going to hit the register of materiality at some point. Their failed attempts to breach the organization, those types of things. So really, when I look at this rule and I look at the requirement to continue to maintain, a certain level of transparency, especially with the SEC and investors, these are the types of activities that really need to be dialed in on mitigation plans. They need to be thought of. They need to be followed up. And the nice part is that's what should be happening already. So for public companies, this really shouldn't change things. We should learn from, the environment around us, and we should learn from these near misses.
Yeah, that's all valuable advice. I'm going to turn away to more broadly what companies can do to reduce risk. And so there's three major ways to do that, really. We can segment it between reducing the likelihood of an attack, reducing the impact of an attack, and reducing the fallout. And so we're going to go through a few topics related to each of those, and also remind you all that if you have specific questions, feel free to drop them in the moderator Q&A or the chat. But starting with the first area, we're seeing a fair amount of action in new and expanding regulations that specify more and more specific safeguards. And one of the broadest potentially applicable sets of regulations has explicitly come out of the privacy regulatory space, and that's the California cybersecurity audit regulations. And so I wanted to raise those and talk a little bit about the effect that they're going to have on our planning. But Demian, I wonder if you could start by explaining a little bit about how they're proposed to work and the impact they may have on companies that fall under those criteria.
Sure. Yeah. The CCPA right now it's a proposed regulation that would require companies to conduct independent audits of their cybersecurity practices. There's a couple of things that are, in addition to just the general expense, which is going to be significant for companies who need to conduct these audits, because they are required to be very thorough and they address very prescriptive sets of requirements. And, the companies are required in these audits to address whether they've met requirements, whether they've addressed particular risk areas, and if they haven't, why not? And so the requirement here is to have an independent audit. One of the things that has an impact on is it makes it more difficult to have a privileged audit. Because the independent auditors are not typically viewed as somebody who is within the scope of the privilege. And that makes it a little bit more difficult. There has been some concern and reaction at the last hearing on the proposed regulations by practitioners who were pointing out, this is essentially this CCPA proposed regulation is asking for companies to create a roadmap to liability in the event that there's a breach. And so is there any protection for it? The proposed regulations as formulated don't have any protections. The agency has not yet had a chance to respond to the comments. We're not at that stage. So we don't yet know whether there will be any protection from liability for the use of these reports, similar to what we've seen in the CERCIA regulations and others, where there's a limitation on the use of mandatory reports. Here, it's an audit. It's not a report. But I think given that it's going to be known to exist by everybody outside the company, and given that it would essentially have a roadmap to liability, because it would describe what security safeguards the company has, what it doesn't have, there needs to be some protection in the view of the practitioners, and we'll have to wait and see with whether or not the final or even the next round of proposed regulations account for that. I think it's important to touch on a little bit like what types of requirements are being addressed or required to be addressed under the proposed regulations. So, these include some things that are pretty basic, like, do you have multi-factor authentication? But a large share of, our client base, hopefully, and the companies out there do have some version of MFA on some of their services. But that's one area. But it gets more specific than that, whether or not the company has encryption for sensitive data in transit or at rest, whether the company has implemented zero trust architecture, whether the company has a robust inventory of its assets. And that's something that's actually hard, even for companies with very advanced and mature compliance programs. Because if your company has grown over the years or over months, chances are, you've lost track of something. And I think that, having a fully complete inventory of your, information security, IT assets and your data, that's going to be a challenge for a lot of folks. There are requirements for examining whether or not the company has centralized audit logs. And then it also includes, a specific evaluation of the company's retention practices. So these are areas that we're all very familiar with if you practice in this area, but a lot of companies, maybe don't address all of them and don't lump them all into one non-privileged document that is going to be known to exist by everybody, regulators, the plaintiffs bar, and everybody else, and frankly, hackers. People could target the existence of an audit like that, and find ways to leverage that. So I think that there are a lot of challenges that are posed by the regulations in their current form. We're hopeful that the agency will be, receptive to some of the comments that have been put forth by practitioners across a range of industries.
Yeah. That's a really good summary of the ways in which I think a lot of very kind of straightforward things we hear a lot about in the security area, like MFA, it doesn't seem crazy when you read it until you think about the fact they're creating this document and that it's not the same audit that other companies have engaged in and thought that I'm going to set up this type of framework and I'm going to audit against that. It's not that. And those types of audits don't, as written, satisfy this requirement. So it's a new and kind of separate obligation. Dan, I wonder if you could talk about how companies should deal with this kind of now. I mean, we're, probably a year or two out, but given the potential of creating a document that's a roadmap to your weaknesses, how do you think about these regulations right now?
Demian did a great job sort of summarizing it. And I think if you hold up all the summaries of all the requirements against all the applicable regs, is where you look for where there are at least efficiencies, and then consider what kind of pre-work or preparatory work you can do towards realizing those efficiencies to not only reduce cost, but also reduce the amount of chatter and involvement and sort of, add additional documentation that might be needed in order to successfully complete an audit. I think obviously you just have to stay aware of what's going on as this develops to make sure you are looking for, with your counsel, the best ways to address this and protect this information as closely as possible. But it's unfortunate to say, because I'm a broken record in this panel of, like, you have to think ahead of time. You have to dedicate the time and the mind share and the right members of your team to look at this ahead of time, so you're not catching up to it. And I think by being ready for it, you can make more efficient work of it. And also, hopefully, when I do things efficiently, there's also less words, there's less exchange of information. It's just a more concise package, and drill it down to the smallest surface area as possible. I went to the doctors for my annual 2 years ago, and I was walking down the hallway, and the physician's assistant was like, "Jump on this scale real quick." I wasn't ready for it, so I had a laptop and my coffee, and I stepped on it, and I was like, "This is," and she recorded my weight. And was like, "All right, follow me." And the doctor's like, "Wow, you gained a couple." And I was like, "Whoa!" And then so this year I was ready. So when we got to that, I only had car keys with me, right? I made it. I was ready for it. So it's that idea of, from an assessment to an audit, you have to think about how to make it more efficient, because you're going to be measured against it, and what does it mean for you in the long term. And I think the other thing is, if you have change in your team, and especially I think across all size entities, think about when you're incorporating a new team member, what their practices mean versus their old team member, right? Your new CISO is going to say the last CISO wasn't doing a great job. Everyone is going to sort of pass the blame back, and really consider what that means as far as communications, and also what it means for that preparation. It's going to break down a little bit of culture too, and making sure that you're taking the long view on this and not the 1 year at a time approach.
Another kind of more broadly applicable regulatory body, but under the same heading of thinking about a broad variety of things to comply with, is, of course, the FTC. And they continue to comment on adequate security in their decisions, and they clearly have strong opinions about certain practices that are appropriate to mitigate risk. So I wonder, Adam, if you could talk about some key emerging themes from the FTC's recent decisions that touch on security.
Yeah, happy to. And, I think it's clear that the FTC really is viewing consumer data privacy and security as within their scope of influence. And I think, the decisions really over the last 2 or 3 years are really highlighting, their view that consumer data is something that's at risk in the United States, and something that they're really stepping in to try to address. Whenever I think about the FTC, you always have to remember that these cases are really originating out of Section 5, which is really unfair and deceptive trade practices. This is a consumer protection statute, and it really is looking at the promises that you're making to consumers. So in a lot of the security cases that you see, when it's sort of table stakes security, like MFA, encryption, sensitive data, those are things regardless of the promises that you're making to consumers. I think that those are things that need to be done now with any consumer, or you're really at risk of having an unfair, deceptive trade practice. There are certain controls that are table stakes. The other thing to remember also about Section 5 cases is, when I look back at this 5 years ago, when clients used to say, "Hey, what am I going to get sued for? What is the thing that really is the most risk of plaintiff's lawsuit, or government enforcement, I'd always, whatever the, hot cyber threat at the time would be my answer is, hey, we got to protect against this. Now I really think we need to protect against ourselves. The severity and the focus of the government is really on this consumer data. And we need to be really careful about what we're telling consumers we're doing with their data and how we're protecting it. Control frameworks are great. Compliance is great. But what really worries me is when companies kind of use sales processes to describe things that really should be factual. And, control frameworks are a great example. Everybody has some sort of certification that they're now applying to. And what worries me is by bringing that out to the public and saying, hey, I meet all of these different controls and, I'm certified and, we have great compliance with this and fantastic scores on all these things. To the extent that you're not properly documenting those things, that in and of itself becomes an unfair trade practice to the extent a consumer, hears those types of promises. So ultimately, it really comes to being more professional and more strict with the way that you're describing your data security practices. There has to be some foundational step and some foundational control framework or, cybersecurity control vision that is out there that you're complying with to do any sort of consumer work. And then it's really looking at, your practices, avoid statements like best in class security, because that opens it up for, potentially any security function or tool to be fair game. If you're not implementing that, obviously you weren't best in class. So it really goes to a point where I think data privacy and security need to separate a lot from, sales and advertising. And we really need to get down to being factual and making sure that we're backing up those statements so consumers really understand how we're using and disclosing data.
Those are really good points to think about the unfair and deceptive practices and the lens they take in their general enforcement. They also, though, have enforcement authority or regulatory authority over particular parts of the economy, like the health data apps and non-bank financial institutions, where they put out breach notification requirements relatively recently. And even those aren't going to be directly relevant to most folks, they really show how the commission has some developing views about particularly, I think, the lack of risk and making these incidents public. And so, Dan, I wonder if you would talk a little bit about that and what you think those rules are telling us about their approach to notice and disclosure and risk assessment.
Yeah, I think that the headline probably continues to be their development as like the regulator of privacy at this point and expanding that. Because here we're talking about a final rule that goes into effect in just under a month or so that will require notice within 30 days of detection or discovery of an incident. If it is perceived to, or if it's understood to affect over 500 customers, and if there is customer information involved in any unauthorized, what they described as acquisition, and then also commented that acquisition includes access to add a little extra confusion to everybody's interpretation. And with that report that's due to them within 30 days of notification, they will publish it on a database. So come mid-June, I think we're going to have a new interesting collection of information to start reviewing, and it applies to all non-bank financial institutions of any size. So we have now another competing reporting obligation for all of these entities, and we add it to the matrix of everything else that we are trying to comb through data and consider. You can imagine an entity that is just stacking up the multiple criteria by which to discern whether or not their data has been involved. And 30 days is not a lot of time, to understand exactly how many people you have, or necessarily what kind of customer information about those people is involved. And just to pile on this a little more, the definition of customer information is more expansive. So we really have another way to look at it would be if you took all the state data breach notification laws and refined cherry picked some of the most restrictive pieces of it and put them all together. You have sort of this monster of those requirements to address, and so yeah, multiply it. And so therein comes the need to prepare for the potential public and third-party scrutiny from these disclosures being published on a database and studied by other parties, while also trying to continue an investigation. I think there's probably been well-tread commentary today and across all breach counsel of it adds layers of complexity and it adds layers of need for manpower to respond when there is incoming communication needs across what is already potentially a complex or even simple incident response situation. So it's going to be a very interesting March 14th and beyond.
Yeah, great. I'm going to turn a little bit back to pre-attack best practices and talk about kind of practical issues. And since we have a large swath of experience here, I'm going to ask each of you to talk about what have you seen in privacy practices that have turned out to make an incident just so much worse. So chance to tell some more stories, sanitized, of course. Demian, let's start with you.
So, I mean, I think where my mind goes is exceptions to the rule. I think we've seen that, the large breaches with the very impactful fallout, often and too often come from some part of a complex system or a complex organization that maybe had the right policies, but there were exceptions to the rule. Whether they were explicit exceptions, recognized by management, or they were exceptions that everybody knew. That group isn't patching, within a day. That group isn't patching within the same time period as other folks. That area is not subject to retention rules because we're using it in a different way, purging rules in particular. That's where I think, companies need to really think about compliance, from start to finish, and to make sure that exceptions are documented and hopefully thereby minimized. Because whether it's an unstated and, tacitly accepted exception or an explicitly recognized one, people are going to be able to second guess that later. And at least if you make sure that the exceptions are explicit, it's more likely that they're exceptions that are worthwhile and justifiable, as opposed to tacitly accepted, that group operates differently or that system operates differently, so we're just going to sort of ignore it, and then it comes back to potentially bite you later. It looks like it's a violation of your policy. So I think that's the area for me that overall compliance maturity and making sure exceptions are either eliminated or documented and properly justified.
Dan?
Yeah, this is a whole other topic, but especially because of mergers and acquisitions, and also when we just see our entities changing platforms of what they're doing with data and how they're migrating that data, and then what other reservoirs of sort of the old platform data may be. Now is a great time to really invest further in data mapping and understanding what can be eliminated because it's outside of record retention, because it was otherwise forgotten, and really it's shrinking the surface area as we're all talking about now to make sure that if there is an incident, that there is less data at risk. And unfortunately, to speak to just the human nature of it, I think when you get through a platform migration, when you get through an acquisition, we often see these vestigial databases and other reservoirs and data pools that create a whole headache, after they've been forgotten. And so making sure that is part of the process, the post due diligence, post acquisition piece, and making sure that is part of after the migration between a software should just be built into the protocol, and avoid that, having to explain why you have something from 2 decades ago that no one that is still around even recognizes, but it's there and it has to be dealt with after an incident. And I think we've all unfortunately been there, and it's the toughest pill to swallow.
Adam?
Yeah, you guys have kind of taken what I was going to talk about. First, I was going to talk about shadow IT. So I think I'll get down to basics here. One of the risks that we see just over and over and over again is not following policies, right? You have policies that are in place. They are, in many cases, very well structured. They are in place to mitigate risk in whatever area. And we see sort of over and over and over again, just a breakdown of those policies, which one, I'm sort of the opinion that data breaches are going to happen. It's just sort of a cost of doing business at this point. But really what we try to do is we try to mitigate the damage from those. And over again, I kind of see these self-inflicted wounds where, we're bringing in shadow IT, we're not fully complying with our third-party assurance policies. So certain vendors, aren't being assessed because, hey, development needs them and, developers are a different breed. So we don't look at those types of things where there are policies and procedures to do that. We see over and over and over again, sort of, a risk assessment not being completed or business priorities getting in the way. And while, policies are never going to be 100% at preventing a breach, it gives us a whole lot of mitigation, especially when dealing with regulators, when dealing with plaintiffs' attorneys. If we have well-articulated policies that we're following, it puts us in a much more defensible position than, hey, we had this policy that we didn't follow. And it's impossible then to prove that, our negligence or our not following those policies weren't the root cause of that incident. And, we're in a situation where we're playing defense against, infinite number of attacks with finite resources. So really, adhering to those documents and making sure that, the functions in those documents are followed is really something that, I'll put out since Dan and Demian just stole my stuff.
Well, to kind of combine what was said there too, like one of those policies is keeping your data where the data map says it is. And if you're not doing that and you're, exporting an Excel file that has everyone's social security numbers on it, I say that like that's the craziest thing anyone would do, but I take call after call where people have everything's checked off. This data is secure, this data is here, this data has a system of record over here, until I ask them if their file server is in scope. And everyone's kind of trash pit of whatever they've been doing, and that's where the terrible things happen. So even though it might be entirely against policy, so that's where kind of the rubber will meet the road, and you've got something that was relatively lined up turn into kind of a mess, and takes a really long time to bring back and to mitigate from. And I'm also wanted to bring this back to kind of a breach in the news right now, which is the Change Healthcare developments. And Adam, since I know that's kind of in your area specifically, I wonder if you might talk a little bit about the lessons the companies can learn from what's gone down there.
Yeah, happy to. Obviously no specifics because I assume everyone on this call is somewhat involved in that in some way, shape, or form. But, there's a couple of things that kind of jump out to me. And, the first is, the vast majority of this call, like we're now in HIPAA world, we're talking about confidentiality breaches, right? We're having, loss of data or improper, sharing or uses of data, with third parties in the healthcare world. But under HIPAA, it's really important to realize that there's sort of three paradigms of breach reporting. There's confidentiality, availability, and integrity. So when I start to think about, vendor issues, I think it's really important for companies to understand, what happens when they lose availability of data or they lose potentially the integrity of data. How ultimately, will OCR and, other third parties deal with that? So I think to me, it's a little bit of a wake up call, and I'm talking to our clients about it is, look, we also have to, in our risk analyses, we also have to get serious about these additional paradigms. I think it again highlights, third-party assurance, right? We as an industry, especially in healthcare, we need to look and make sure with all of our vendors that we have the appropriate technical and contractual controls in place to make sure that we're covered from both an ability to deliver services as well as from a liability perspective. We're seeing over and over and over again these large third-party breaches, and companies are not made whole by the deals that they're cutting. And, there's been a stream of, I'm not going to mention any names, but there's been a stream of, pretty high profile third-party breaches now over the last few years. Finally is redundancy. In IT systems, we think about redundancy all the time. What if the primary database goes back? How quickly can we, recover? How quickly can we get data up? I think we really need to focus on this with our vendors is, looking at redundancy, looking at our own systems, looking at the number of vendors we're using for things and making sure that we have the ability to deliver even in situations where, availability goes down. We're almost out of time, so I'll keep that short, but that's sort of what's popping in my mind right now when we're talking to clients about.
But Adam, that's true. That's great because it's true of everything we've talked about, right? Every other regulation that we're talking about is you could just apply what you said to all of those pieces. So it's a great summary of something that we sort of skipped past this afternoon is vendors, and making sure you have those controls.
There's been an active discussion in the chat about both kind of what we said about policy versus reality, as well as the issue of how the audits are going to work. And I think it's great to see that people are kind of answering some of the questions themselves. I think that the issue we have, generally speaking, with those audits is they're kind of still in flux, and we're hoping that there'll be some changes based on additional comments. But right now, they're not posed to be satisfied by things like a SOC 2 or a PCI audit, and so they would be different. That's one of the questions that came up a couple of times. And then I also want to turn to another one that we got that talks about the idea that, at least sometimes, and particularly with the one we just talked about, it's going to take a really long time to assess the breach and actually come out with either a reasonable description of what happened or to provide those breach notifications. And there's a widespread perception that's not especially reasonable, but we've all kind of been in a situation where we understand how it takes that long. Do we think that regulators should clamp down on that, and are they? What you guys have thoughts on that?
Let's hope they don't.
Yeah.
I think, look, it's a challenge to be able to, when there is a significant breach of a large amount of data, especially if it's unstructured or the sort of left behind data, from a merger or from some other different part of the system that wasn't aligned with the overall approach. It takes time. And I think that, we have seen, both on the class action side and on the regulator side, a fair amount of noise. It's a standard question and complaint or allegation that this was taking too long. But I think that practitioners need to be firm and sort of articulate it. It takes a long time to get it right. I do think the qualifier is like if you're dealing with an event that is either disclosable or impacts the SEC disclosures in some way, even though the investigation as a whole may take a long time, you may need to speak about it in the interim, and you need to be very careful that you speak about it carefully. And I think that we will all, I'm sure, argue that there needs to be some grace here for the uncertainty. But it's a really tough position to be in when you don't really know the answer, but you've got to speak at some level. And that's really, I think that's a different problem than the one that it takes too long to get the notifications out, right? But they're related because you're in a tough spot either way.
Well, especially when the alternative is kind of tell everyone that they're affected, and that's not what any of these people actually want either. They just want it better.
Well, the plaintiffs more than like it. I don't.
Dan or Adam, you have any concluding thoughts?
I think Demian touched on a great one, which is you have to consider how to mitigate that risk and also be sort of factually based and prepared for it, with also describing to regulators like this is where we are, and I will continue to address your questions or follow up with you and try to establish that rapport can help set expectations, and that this isn't a sort of a hide the ball situation. This is the length of time this process will take. It's not for willful refusal to acknowledge that anything happened. It's how the process runs.
Yeah, I'll just add on, especially in my world in HIPAA, I spend a lot of time there. HIPAA was written way back in the 1900s. And, honestly, this market has changed so much since that point that those hard deadlines, like the 60 days, that really, I think, needs a policy solution. Because, plaintiffs do look at that as, a hard and fast rule. And we all know that, 60 days is an incredibly short time frame for certain breaches. So I think, the standards, as soon as practical, those types of things, as long as you can show good faith, is really the way that it should be handled. Unfortunately, policy solutions are needed for that.
Yeah, there's also probably a room for effective and crisis communications there too. It's not just the lawyers and the coming up with what to say, but being able to explain why it's taking a long time. If you're in a situation where, as Demian pointed out, like you've had to go public with the incident, but you've got a bunch of people waiting on you. So